Opening and Introduction. Welcome to GDPR Training by Complico. In this module, we will focus on one of the most important and practical elements of the General Data Protection Regulation: legal basis for processing personal data. Under GDPR, organizations cannot process personal data simply because they want to. Every processing activity must be justified by a lawful basis. Choosing the correct legal basis is not optional, it is a legal requirement and a foundation of compliance. By the end of this module, you will understand what a legal basis for processing is, be able to identify the 6 lawful bases under GDPR, know how to choose the correct legal basis, understand why consent is not always the best option, recognize common mistakes and compliance risks. The 6 legal bases under GDPR. GDPR defines 6 lawful bases for processing personal data. Let's walk through each one in detail. Consent. Consent means the data subject has freely given, specific, informed, and unambiguous permission for their personal data to be processed. Key requirements for valid consent: it must be freely given, no pressure or imbalance of power, it must be specific, clear purpose, it must be informed, the individual understands what will happen, it must be unambiguous, clear affirmative action, it must be easy to withdraw at any time. Contract. Processing is lawful if it is necessary for the performance of a contract, or to take steps requested by the individual before entering into a contract. Examples: processing delivery addresses to ship a product, using payment details to complete a purchase, managing employee payroll and benefits. Legal obligation. This applies when processing is required by law. Examples: keeping employee tax records, reporting financial transactions to regulators, maintaining health and safety records. Vital interests. Processing is lawful if it is necessary to protect someone's life. Examples: sharing medical data in an emergency, providing critical health information to emergency services. Public task. This basis applies when processing is necessary to perform a task in the public interest or as part of an organization's official authority. Examples: government departments processing citizen data, local authorities managing public services, universities conducting public interest research. Private organizations usually cannot rely on this basis unless specifically authorized by law. Legitimate interests. Legitimate interests allow processing when it is necessary for the organization's legitimate interests, as long as those interests are not overridden by the rights and freedoms of the data subject. Examples: fraud prevention, network security monitoring, limited direct marketing to existing customers. Legitimate interests assessment, LIA. To rely on this basis, organizations must conduct a balancing test, identify the legitimate interest, assess necessity, balance against the individual's rights. Common mistakes to avoid: relying on consent when another legal basis is more appropriate, failing to document the chosen legal basis, using multiple legal bases, just in case, assuming legitimate interests always apply, not updating privacy notices. These mistakes can lead to non-compliance and enforcement action. Thank you for completing Module 5, Legal Basis for Processing, as part of GDPR Training by Complico. In the next module, we will explore data subject rights and how organizations must respond to them.